Welcome to Denver Startup Week. I'm Tammy Dorr, President and CEO of the Downtown Denver Partnership and co-chair of Denver Startup Week. This year marks the 10-year anniversary of Denver Startup Week. DSW has been the catalyst for lots of change over the past decade. And this week, we're coming together to celebrate the past and dream big for the future. We are able to bring Denver Startup Week to this community thanks to our 2021 sponsors. Thank you to our HQ and title sponsor, Amazon, and our title sponsors whose leadership makes this week come to life. Capital One Cafe, Downtown Denver Partnership, Fluid Truck, Hotel Engine, and WeWork. And our track sponsors who have made all of the great content you're hearing today possible, our founder track sponsor, Kickstart, growth track sponsor, Friday Health Plans, developer track sponsor, Quizlet, product track sponsor, Palantir, our designer track sponsor, Battery 621, and the Public Works, people track sponsor, Exactly, and spotlight event sponsor, Strat Labs. Our headline event sponsors are bringing the excitement to the week. Thank you to B-Side Fund, Colorado Public Radio, Comcast, Coors Brewing, Denver Pavilions, Entrepreneurship at the University of Denver, JP Morgan Chase, Method, Moss Adams, Pi Insurance, Promontory Mortgage, Path, Southwest, Tattered Cover, and VF Venture Foundry. Finally, thank you to our partner and member sponsors, all listed on the screen. Please say thank you to these companies as you enjoy our hybrid Denver Startup Week. And don't forget, use the hashtag DenStartupWeek to share your experiences and moments of inspiration on social media. Have a great week.
The Public Works is a Denver, Colorado-based design, fabrication, and multimedia marketing firm that allows your company to craft an authentic presence to your target audience. For the past 15 years, the Public Works media team has been telling stories with words, pictures, and films. Our unique approach to brand storytelling allows us to get strong reactions and results from our content. We work in experienced and nimble teams with our crew of producers, directors, and cinematographers that all have first-hand experience and international presence. We are fortunate to have amazing clients that allow us to get wherever we need to go with the right tools for the highest production value. Lots of people can take a pretty picture. Just look at Instagram. While we believe our images speak for themselves, what really sets us apart is our decades of experience, our network, and our ability to make shit happen when it counts. We love bringing unexpected partners together to create added value for everyone, and most of all, we love when we finish a job confident that we've not only executed, but elevated the end product, and we know that everyone involved enjoyed the process. Our company was founded on the idea that life is about learning and teaching through every experience. We apply a strict discipline of work hard, play hard, and make great fucking work. We amplify awesome. We surround ourselves with the best and feed off of infectious innovation, ideas, collaboration, and building long-term friendships and partnerships. Contact us anytime for a meeting at our office, golf course, or on the chairlift.
Hi everyone, welcome to Denver Startup Week. I'm Castle, the Designer Track Chair and member of Denver Startup Week Organizing Committee. Before we get started, the Denver Startup Week Organizing Committee acknowledges Indigenous people as the original owners of the land on which we reside, which is the traditional territory of the Ute, Cheyenne, and Arapaho peoples. We acknowledge the painful history of genocide, ethnic cleansing, stolen land, forced removal, and forced occupation of their territory. And we honor those who have stewarded this land throughout generations and all other Indigenous tribes and nations who call Colorado home. Thank you for joining us in the 10th anniversary of Denver Startup Week. At Denver Startup Week, we strive to make all of our sessions a space where attendees can connect, learn, and grow regardless of age, gender identity, gender expression, race, ability, sexual orientation, or the combination of those identities. There's something for everyone at DSW, thanks to all of our community members who submitted their best content to make the week what it is. And thank you for joining us. Thank you to our sponsors for their support in helping us keep DSW free and accessible to all, especially our designer track sponsor, Battery 621, and the Public Works. With that, please enjoy the session and the entire week.
Oh, hello there. I'm John Milgram from Milgram & Daskin. We're a full-service law firm based out of Denver. We're proud to be a certified B Corp, a member of 1% for the Planet. This is our third year presenting at DSW. We're thrilled to be here. As creatives, your intellectual property represents your most valuable asset. Today, we'll walk you through the different types of IP and best practices for securing your IP in a presentation we like to call Putting the IP Back into HIP. First, Laura Marmelstein will talk about patent protection. Next, Cooper Tollin will discuss copyright and trade secret. And finally, Emily Kurth will take us home with a riveting review of trademark. Although our presentation is pre-recorded, we're all watching and present, so please feel free to post questions in the chat, and we'll address items during the Q&A session at the end. Alternatively, each attorney's contact email will be provided at the end of his or her segment. We encourage follow-up by email and would love to hear from you. With that, pass the ball to you, Laura.
Thanks, John. Hi, I'm Laura Marmelstein. I'm a patent attorney at Milgram & Daskin. Today, I'm going to discuss patent basics, starting with what a patent is and the different types, why a patent is valuable, and when to consider procuring a patent. My hope is that by the end of this presentation, you take away a basic understanding of patents and the value that they can provide. Let's get started. What is a patent? A patent is an intellectual property right that grants the owner the right to exclude others from making, using, importing, offering for sale, or selling the patented invention in the United States for a limited period of years. What is granted is not the right to make, use, offer for sale, sell, or import. So it's the right to exclude, but not the right to use. A good example is someone has a patent on a stool. So they have the right to exclude others from making or selling a seat with 4 legs. You're able to obtain a patent on a chair. So basically a stool with a back. So you have the right to exclude others from making or selling a seat with 4 legs and a back. Now, you have the right to exclude others essentially from making and selling a stool with a back, but you can't just go and sell your chair because you'd be infringing on the stool patent since you'd be making and selling a seat with 4 legs. So it's the right to exclude, but not the right to use. So there are 3 different types of patents: utility patents, design patents, and plant patents. In the next couple slides, I'm going to focus on design patents and utility patents since those are more common. I will not be talking much about plant patents as they're less common, but know that they're an option for any distinct and new variety of plant that has been asexually reproduced. All right, I'm going to start with utility patents. Utility patents protect the functional characteristics of an article, so the way it's used and works. Utility patents are granted for any new and useful process, such as a manufacturing process or software, machine, such as a car engine, article of manufacture, such as a new camera lens or a chair, as in our previous example, a composition of matter, which includes pharmaceutical drugs, or any new and useful improvement thereof. The invention must be new, novel or new, and non-obvious. Novelty means there's nothing that predates your technology that is identical. Anything that predates your technology is referred to as prior art. So if you have one feature that's different than the prior art, it could be considered novel. Non-obviousness is a little bit more difficult of a hurdle to overcome. It essentially means that your invention needs to be sufficiently different from what's existed. So if your one feature that's different is only a minor tweak that anyone could have thought of, it might be considered obvious and not protectable. There are some things that you also cannot patent, such as abstract ideas, laws of nature, or natural phenomena. I mentioned previously that you can obtain protection for software as a process, but software needs to be tied to some sort of technology. Software applications are often rejected as abstract ideas, and this is often where the software is simply recited as a code or a set of instructions that's detached from any medium. What you need is a technical solution to a technical problem. A law of nature would include any naturally occurring principle or relation, such as E = mc squared, or the law of gravity. A natural phenomena or a product of nature is something that's naturally occurring. For example, a cloned sheep is identical to sheep found in nature, so that would not be protectable. A utility patent provides a 20-year monopoly. They are often more costly to obtain than design patents, but they typically provide broader protection. It is a pretty lengthy process to obtain a utility patent and often can take 3 to 4 years to get a patent to issue. So next I'm going to talk about design patents. A design patent protects a new, original, and ornamental design for an article of manufacture. So it's the way something looks. This includes the shape or configuration of the article or the surface ornamentation that's applied to the article. For example, in the design patent in the lower right corner of the screen, that is for surface ornamentation on the inside of an article of clothing. You can also see on the screen the Apple's slide to unlock, the Apple Watch, and Crocs shoes, which are all protected by design patents. So they're protecting the way these things look, not the way they function. These design patents prevent others from copying a similar design or the same design. Because they're protecting the way it looks and, against others making a similar or the same design, design patents provide more narrow protection than a utility patent, but they are cheaper, quicker, and often easier to obtain. Design patents provide a 15-year monopoly, and they can typically take 1 to 2 years to issue, which is significantly less than utility patents, which, as I mentioned, can take 3 to 4 years to issue. I do want to note that you can have both a utility patent and a design patent cover the same product. So the utility patent would cover the functional aspects of the product, and the design patent would cover the ornamental features, such as the way it looks. Why are patents valuable? As discussed previously, a patent provides a limited monopoly, either 20 years for utility or 15 years for design patents. Also, as noted earlier, they only give you the right to exclude others from using your technology. They do not give you the right to use. So you still need to be wary of whether your technology is incorporating patented technology. This monopoly and this right to exclude are valuable because they keep competitors out of your space. So you can develop your position in the market before anybody else. Patents are intellectual property assets that can be licensed or sold. So you can license it to others and make a profit that way. Further, patents are attractive to investors. They show you're serious about your technology and that you think it's valuable and new. Now let's talk about getting started. So you've thought of this new invention that you think is super unique and has never been done before. A good place to start is do some basic research to see if anything out there is similar or if this has been done before. I've actually had clients come to me thinking that they have this brand new technology, and then they do some research and find out that the exact same thing has been done and they can't obtain a patent. Before you file a patent application, your invention needs to be reduced to practice. Essentially what this means is that you need to know your invention will work, and you can describe it with enough specificity to enable another to make and use your technology. For this reason, it's generally better to file with a prototype so that you have worked through the kinks and that you know it's going to work, but this isn't necessary. You can file with an idea so long as it's sufficiently concrete. Again, this means that you can describe it with a degree of specificity to teach another how to make and use the technology. You want to make sure that you're considering all the different variations and improvements that can be done in order to prevent design rounds. And another key consideration when you start out is to avoid a public disclosure before you file a patent application. This is super important. A public disclosure includes a non-confidential disclosure. So a disclosure that without a confidentiality or non-disclosure agreement in place, a public use, sale, or an offer for sale. Examples of public disclosures include trade shows, press releases, publications, websites, product launches, advertising and marketing materials, and discussions with people outside your company, particularly without a non-disclosure or NDA in place. In the US, there is a 1-year grace period to file a patent application after a public disclosure, but if a year has passed since your public disclosure, you can't obtain a patent. Most foreign jurisdictions do not have this grace period, and you will lose your patent rights in those countries if you disclose before you file. So best practice is to file before a public disclosure. To summarize, patents help you protect your novel inventions and technology. They give you the right to exclude, but not the right to use. They provide a limited monopoly, and you want to file a patent application when you can explain your novel invention with sufficient detail to teach another how to make and use it. You want to file before a public disclosure, and there is 1-year grace period in the US, but it's best practice to keep your invention secret until you file. Thank you so much for listening today. I hope you now appreciate the value of patents and have a basic understanding. If you have any general follow-up questions, please feel free to reach out to me at the email provided. Next, I'm going to pass it to Cooper to discuss trade secrets and copyrights.
Thanks, Laura. Hi, I'm Cooper Tolan, and today I'll be talking about trade secrets and copyrights. So let's get started. I'm going to share my screen with you. All right. So to begin, what is a trade secret? A trade secret is information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent value from not being generally known and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So that's the fancy law talk, but let's just talk about some real world examples of what a trade secret actually looks like. So one example is Kentucky Fried Chicken original recipe. They've got a blend of herbs and spices that are secret. Nobody knows what the actual herbs and spices or the ratios that they use. And you've also got Coca-Cola. Nobody knows exactly how to replicate Coca-Cola. Some other examples could include Google's search algorithm or different types of software, including self-driving software. And the reason these things are valuable is because no one knows how to imitate them. There's lots of colas out there in the supermarket, but there's only one Coca-Cola. There's lots of fried chicken recipes out there, but there's only one Kentucky Fried Chicken. Now, a trade secret does not protect secrets that somebody goes out of their way to reverse engineer. So trade secrets are designed to protect your secrets from a bad actor trying to steal the secret from you, but it doesn't necessarily protect you from somebody, really trying hard to make Kentucky Fried Chicken at home. So let's talk about protecting a trade secret. To protect a trade secret, there's a few things to keep in mind. The first is that they're protected by both federal and state law. A new federal law, the Defend Trade Secrets Act, was passed in 2016. That created a private cause of action if the trade secret is used in interstate commerce between two different states. So the best thing to do to protect a trade secret is keep things as need to know as possible. For all of our examples so far, KFC, Google's algorithm, Coca-Cola, only a few employees probably know the full recipe. You want to keep that minimal and at a high level. You don't need every employee to know the secret recipe for Coca-Cola. You only need the top level people, or maybe 1 or 2 people, to know every element of the secret. Another thing you can do is employ non-disclosure agreements, or NDAs. So NDAs are really great because they create a confidential relationship between you and the other party to the NDA. And that confidential relationship allows you to share trade secrets without the fear that they're going to get stolen. And an NDA creates a confidential relationship that continues even after the relationship you have with that other party ends. So the confidentiality continues on into the future. So NDAs are probably one of the best tools you can have in your arsenal of protecting your trade secret for that very reason. Finally, You want to make sure that you're training, communicating, and monitoring your employees and other people that have access to the trade secrets about how valuable and the importance of keeping these things secret. The key thing to remember with trade secrets is that you want to take all reasonable efforts to keep it a secret. And creating policies and monitoring those policies are a great way to do that. One recent example of a trade secret case in the public eye was Waymo and Uber. An employee for Waymo downloaded about 14,000 files and then left and took those files with him to Uber. And the files contained a lot of confidential information about Waymo's self-driving technology. Ultimately, that was a bad actor, a bad employee stealing that information. Waymo may have taken lots of reasonable steps to protect it, but they probably could have done a better job to ensure that people leaving their employment didn't have access to those kinds of things. So always something to keep in mind. It can even happen at big companies like Waymo, which is owned by Google, and it's not always going to be your fault, but you want to do everything you can to keep things as secret as possible. And with that, let's move on to copyrights. So what is a copyright? A copyright is an original creative work that's been fixed in a tangible medium. So there's a wide variety of tangible mediums. It could be a book, it could be a song, it could be a painting, it could be a photo that you take on your phone. Any type of creative expression that's fixed in a tangible medium can be copyrighted. So the key to copyrights is that they protect the creative expression itself against copying. Doesn't necessarily protect the underlying ideas or facts contained in the work, and it doesn't protect against independent development off the original. So if somebody builds off of the original. Copyrights, unlike patent or trademark, they're created automatically at the moment of fixation, but you can obtain a copyright registration. So for example, when a musician like Kendrick Lamar makes an album, they obtain copyright to the songs the moment they create them. As soon as they create the album, they recorded in the studio, they own the copyright to that work because they created it. They could get a registration, but they have that right as soon as they put it down in the studio. Copyrights give you, as the owner, the right to make copies, perform or display the work in public, or sell or lease the use of the work. And another thing to keep in mind for copyright is that owning a copy isn't the same thing as owning the copyright. So the owner of a copy doesn't possess the copyrights. They don't possess the rights that flow from those copyrights. So a good example of that, again, if you own the album, Good Kid, Mad City, in your music library, you just own a copy of that album. You don't actually have the copyright to that work because you didn't create it. You just have a copy. So that's an important distinction to keep in mind. So how do you protect copyrights? As I said, copyrights are created automatically, but you do want to consider obtaining a copyright registration, because without a copyright registration, you can enforce your copyright rights in court. And you're also entitled to statutory damages and attorney's fees for copyright infringement if you have a copyright registration. So copyright registration is relatively cheap, but it allows you to enforce your rights and entitles you to damages, which is pretty powerful for the amount of money that you spend. The best thing you can do to protect your copyrights is to always use a copyright notice, the little C there, on all your published works, and make sure that others are doing the same when they use your works through the contracts that you have. If you're using other people's work, be sure to give them appropriate credit. Be careful what works and rights you're giving to others and how they're using it, and use licensing agreements. Now let's talk about copyright infringement. So this is what happens when you are using something that has been copyrighted that you're not the owner of without their permission. So the key word for copyright infringement is substantially similar. Copy work has to be substantially similar to the original. There's not necessarily a bright line rule for how substantially similar it has to be. There's a variety of factors that courts consider. A recent famous example is Neil Young and other musicians suing President Trump over his use of their music at campaign rallies. Another example could be what I have above with Cars, and then a different version where, that's clearly very similar to the original, but also, they're trying to do something different with it. With copyright infringement, you are liable to the copyright owner for damages, and you can be vicariously liable as well. So that's something to keep in mind. If one of your employees copies or uses something that you don't have the right to use, you can be held liable for that as well. So always, always, always with copyright, be careful. Copyright it can be very tricky. Don't make assumptions. Always check for who has the registration or license to copyrighted material. Always read contracts and website terms of services on websites like Flickr or Shutterfy, anything like that, where you're going to be grabbing pictures or music or any kinds of works that you're going to use for your own purposes. If you don't own it, always check to see what the terms of use are. Another thing to keep in mind is watch out for copyright trolls. Copyright trolls are people who hold copyrights just to make money by suing other people. They're not usually using the work themselves. Oftentimes they're going to send a cease and desist letter to you and ask you for a bunch of money to stop using the mark. So just be careful for those. Read those kinds of cease and desist letters before you pay any amounts of money. Another thing to keep in mind, recent development is the CASE Act of 2020, which stands for the Copyright Alternative in Small Claims Enforcement Act. The CASE Act should help deter copyright trolls in that it institutes fees for bringing copyright infringement claims in bad faith. And it also makes it easier to bring legitimate infringement claims for claims that are less than $30,000. So now there's a new federal small claims court, basically just for copyright infringement claims. Finally, let's talk a little bit about contracting for copyrights. So when you're contracting for copyrights, number one, be transparent. Try to be explicit about works are being used, what those works can be used for, what services you're performing, and the rights that you're granting. You don't want to be vague in these areas. Try to just be explicit as possible. Be fair. Number two, indemnify third-party claims for items that you're providing. Make sure also to get indemnification as to third-party claims that other people are providing the works for, and give clients the use of the copyrighted work that they need. If you're contracting for copyrighted work, you want to make sure that the other party is actually going to be able to use the work that the way that you're intending them to use it. And number three, perhaps most importantly for you, make sure in your contracts that you're retaining rights to use your own copyrighted works the way that you need to use them in the future. Consider things like source code, underlying artwork and designs, anything of that nature where you might need to use it again in the future. You don't want to contract away your right to use that in the future for a project now. So these are all things to keep in mind when you're contracting around copyrighted material. And that's all I have for you today on trade secrets and copyright. If you have any questions, there's my contact info. I'm going to finish up here, and then I'm going to pass the ball to Emily Kurth, who's going to tell you all a little bit about trademarks.
Hi, I'm Emily Kurth, an associate at Milgram & Dascombe, and I'm here to talk about trademarks, specifically what they are, why we need them, and how to go about protecting your brand. So, what is a trademark? A trademark is a sound, trade dress, or image that connects the goods and services to their source. So here we've got AT&T's design logo, the Coca-Cola bottle, Chipotle, and, well, Chipotle's interior design, and the Spotify logo. So no matter where you see these trademarks, you associate them with their brand and their goods and services. You can even trademark a sound, for example, the NBC tones, which I absolutely will not sing right now. Trademarks further serve as quality assurance. You know that when you see a Chipotle trade dress, and when you walk into a building that looks like that, you know that you're in a Chipotle, and you know that where you are is associated with Chipotle and has been approved by Chipotle. And trademarks can also be used as a sword and a shield. So with a trademark registration, you can prevent others from entering the market with a similar brand or similar trademark to yours. Alternatively, if anyone questions the use of your trademark, you have a federal registration to demonstrate that you're entitled to use your trademark and brand in connection with your goods and services. A trademark is protected for the goods and services that it's registered for. So when you apply for a trademark, you need to specify what those are. But there is a zone of natural expansion, and that zone broadens your trademark's protection to goods and services to which you may naturally expand. For example, the zone of expansion for McDonald's, so protected for burgers, McNuggets, the McRib, may extend to other restaurants or food products such as sandwiches. However, McDonald's the zone of expansion does not naturally extend to hardware stores or cosmetics unless you're doing makeup like the Hamburglar, maybe something for them to consider. And this naturally lends itself to the likelihood of confusion analysis. So when determining whether there is trademark infringement, you need to consider the mark's similarities in appearance, sound, commercial impression, as well as whether they have overlapping markets or similar goods and services. And remember, trademarks exist to protect consumers. We do not want consumers to be confused as to the source of the goods. So if you attempt to register a trademark that's really confusingly similar to Coca-Cola or maybe the Spotify logo, then the examining attorney will not allow your mark to register because we want to prevent consumer confusion. So with the likelihood of confusion, it's a good story as why we need to Google our name. It's an easy first step, but one that is often overlooked and forgotten. And a good example of why you want to Google your name, in addition to conducting a much more nuanced and detailed search, which we will touch on shortly, is with Modern Market and Mod Pizza. So Modern Market, we all know it, is a Colorado-based fast casual healthy food chain. And it was formerly Mod Market. Mod Pizza, though, based in the Northwest, had prior trademark registrations and was a fast-growing, fast casual pizza chain. And Mod Market pursued trademark registrations for Mod Market, for its logo, etc., but it was opposed by Mod Pizza for being confusingly similar to potential consumers when that could negatively impact Mod Pizza's business. So the court ruled in favor with Mod Pizza, and it ended up with Mod Market undergoing a multi-million-dollar rebrand to change to Modern Market. And had Mod Market conducted research before, building its entire brand around Mod Market, maybe it had spent a little more time on Google, talked in depth with a trademark attorney, then it could have saved itself a lot of time and money. That's why we highly recommend hiring a trademark attorney to help you navigate this process and guide you through acquiring a trademark, which can be pretty tricky, and we're not trying to toot our own horns here. Let's see. So we've talked about what a trademark is, shared a story that'll keep you up at night if you've just launched your new brand, but why go through all the hassles of seeking a federal trademark registration? So when you have a trademark, you're protected at common law, state law, and potentially federal law if you do submit that federal trademark application. So at common law, you have fewer rights, but they do attach once you start using the brand in commerce, that is, in an outward-facing way in connection with your goods and services. At common law, the first person to use the mark has senior rights to the brand, but those rights are restricted to the specific goods and services that you're using the mark with, as well as a particular geographic region that you're operating in. Conversely, at federal law, you have national rights. You can enforce it throughout the country or use it as a shield throughout the country. Eventually, after 5 years of using your mark, you can claim that your mark is incontestable, meaning that no one can try to cancel your mark and say that you're not entitled to use it. And also having a portfolio of trademarks and IP confers intangible value to your company. Trademarks is the outward-facing brand of your company, and that can be a hugely valuable asset. And consumers' positive associations and trust in a company's trademarks is what gives a company its value often. And if you have federal registrations for your trademarks, then you'll very likely significantly increase the value of your brand. One thing to consider is that not all trademarks are created equal, and therefore not all trademarks are entitled to registration with the Patent and Trademark Office. So when determining what marks are able to register, we need to examine the spectrum of inherent distinctiveness. So only inherently distinctive marks are entitled to registration. What does that mean? So we'll look at the spectrum to talk about it. So at the end of what is easier to register, we have fanciful or arbitrary marks. So some examples of this is the Apple logo associated with computers, Kodak with cameras, the swoosh with Nike. And despite our familiarity with all those brands today, you would not associate a fruit with the tech empire or a type of bear with cameras. Amazon is another really strong example of a fanciful or arbitrary mark, because Amazon, the rainforest, before the existence of Amazon as we know it today, you wouldn't associate it with a company where you can literally buy anything. And on the other end of the spectrum, we have generic marks. And generic marks are not entitled to registration because they're descriptive of the goods and services themselves. And if anyone has a trademark on the name, then it would create a monopoly on those products. We want competitors to be able to use it. An example here is aspirin, brand aspirin. No one can register aspirin as a trademark because others need to use the term aspirin to describe aspirin and exactly what they're producing. In the middle here, we've got suggestive marks and descriptive marks, and this is where it gets a little blurry. And while descriptive marks are not entitled to register because they're like generic marks, just describe exactly what you're offering, suggestive marks are entitled to registration. And like I said, it's blurry here because what we need to ask ourselves is whether there is a spark of imagination, as lawyers often love imagination. So copper tone is a good example of this. So copper tone may suggest the appearance or describe the appearance of one's skin after sunbathing. It's not exactly clear that it's describing sunscreen. And also the inclusion of this little girl and the dog adds a level of fancifulness, which makes it distinctive. So the more it describes exactly what you are selling or offering for goods and services, the less likely it is that you're entitled to a trademark. And whereas the more fanciful or clever or unrelated this word is or this design is with what you're offering, the more likely it is that it's a more suggestive, arbitrary, or fanciful trademark that is entitled to registration. So your mark is not generic or merely descriptive. Congratulations. So how do we go about registering that trademark? So the first step is to talk to a trademark attorney who will conduct both an internet and trademark knockout search on the Patent and Trademark Office's online database, which will inform the strategy of how to move forward, whether there are other marks that may block your application, it's not worth pursuing, or maybe if we want to apply for multiple marks and see what gets through, if you want to apply for the mark with an image or a tagline, because images tend to make it more distinctive on that spectrum of distinctiveness, and adding those designs to make it stand out a little bit more. And when you do file an application, you file either a use in commerce application, a 1A application, or a 1B, an intent to use application. So a 1A application, right now there is a backlog because of COVID with the Patent and Trademark Office, which was already pretty slow. So it is taking about 5 to 6 months after you submit an application for anyone at the Patent and Trademark Office to look at it. So once they do, they conduct a trademark knockout search themselves, and it is a single examining attorney who determines whether or not you are entitled to move forward and achieve registration. Again, that's why it helps to have another lawyer helping you out with your application. So when the Patent and Trademark Office reviews the application, they will spend some time with it, and then they will either approve it and publish it. And once it publishes, it basically puts the public on notice and allows people 30 days to oppose the registration of this mark for any reason, and we don't really have time to talk about that today, but we're happy to answer questions after. I think about 2 to 4% of applications are opposed during that 30-day period. Ideally, they're not, and then you would proceed to registration. That entire process, without any hiccups, can take probably 9 months to a year right now. But most trademark applications do receive preliminary office actions, meaning initial refusals as to why your mark cannot yet register or maybe register at all. So the Patent and Trademark Office issues an office action, and that allows you time to either submit a response to overcome. So that's when you draft, it's mostly lawyers, draft a response saying why the examining attorney has erred in their reasoning and why you are entitled to trademark registration. And alternatively, you cannot respond, which would abandon your application. You have 6 months to respond to that, after which you either proceed to publication if you overcome the office action refusal, or you receive another office action refusal. And then, hopefully you overcome the second one. If not, you maybe talk about some other strategies, maybe a rebrand, hopefully not. And ideally, no matter what, you achieve registration at the end of the day and you bolster your IP portfolio. And the intent to use application is not too dissimilar from the use in commerce application. The first steps are the same, the knockout search, the application, but after the publication period, say that it's approved and makes its way to publication, rather than proceeding to registration, you cannot register the trademark until you are using it in commerce. So when you submit an intent to use application, that means that you have a bona fide intent to use. You're truly meaning to use a mark in commerce. Maybe you've done research, you're talking to potential distributors, marketers, etc. And you are intending to use it and you want to apply now. And we highly, highly recommend applying earlier. The earlier you apply, the more likely it is that someone else won't beat you to it, which happens more often than you would think. So with this, rather than proceeding directly to registration after publication, you would, if no one opposes you, you receive what's called a notice of allowance, meaning that the Patent and Trademark Office is allowing you to register if you begin using the mark in commerce, after which you need to file a statement of use, which is proving how you're using the mark in commerce, and you need to provide evidence of how you're using it. You have 6 months to do that, but that 6-month period can be extended for up to 3 years. So again, if you are planning on using a mark but not yet operating your business, we highly, highly recommend applying for an intent to use application, because it is super important to apply for those marks once you've committed to them, because others may jump ahead of you in line. All right, so some common rejections in those office actions I referenced are the likelihood of confusion, one, which we have been touching on repeatedly, saying that it's merely descriptive of the goods and services that you're offering. Chapstick brand Chapstick had to overcome this merely descriptive refusal. Sometimes that it's primarily a surname, even if it's not someone that you know, or even if you don't think it sounds like a name. If it could potentially sound like a name, definitely specify that it is not a name. Otherwise, you might be hit with a $100 fee, and then you have to go through this process of submitting a statement that it is not a surname. Kind of silly. Also, you may have to disclaim part of your mark. For example, Applebee's Bar and Grill has no exclusive right to bar and grill because others need to use bar and grill. So Applebee's has Applebee's and the exclusive right to Applebee's for restaurant and bar services. However, others are allowed to use bar and grill because that would be unfair for competition if only Applebee's was able to use bar and grill. So post-registration, to gain your incontestability, you need to file declarations and renewals basically between your 5th and 6th years and 9th and 10th years. And then every 9th and 10th period after that. So again, if you want to maintain your marks especially for extended periods of time, definitely hire a trademark attorney to docket those dates because they are easy to forget. And if you do not file those renewals, then you lose your trademark rights, even if you're still using it in commerce. And that happens all the time. So make sure you have someone else docketing those dates in addition to yourself. So some key takeaways: Google your name. Just Google your name before you commit time and effort into building your brand. Talk to a trademark attorney and protect and value your brand. Trademarks are, they're finicky little beasts, but they are very important and add great value. So we highly, highly recommend pursuing them, and we are happy to answer any questions that you may have. Again, I'm Emily Kurth. Thank you for talking to me, and now we're passing the ball to you.